Show every Monday starting at 5 p.m. They can darn sure use the money.
Hi there. This is Marine Wildlife Artist and Conservationist Dr. Guy Harvey. Please listen to the Kelly Kelly Show every Monday starting at 5 p.m. They need to feel worthy.
From the Sunshine State, this is Tampa Bay's 10 Talk.
It's time for FLA Law, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. It is Tuesday evening, and we are here live on radio for you. This is FLA Law on the radio. It's a legal call-in show, so if you have any questions regarding the law, this hour is here for you to answer any questions, for us to answer any questions that you may have. I am a partner at the law firm of Perenich, Caulfield, Avril Noyes, the proud sponsors of FLA Law. And we are the oldest personal injury law firm in Tampa Bay. So if you have any questions regarding personal injury, auto accidents, trip and falls, slip and falls, workers' comp, or even Social Security disability, give us a call, and I'd be happy to tackle those questions. But I am blessed to have a friend and a colleague here as well. Jake Blanchard is here as well to answer questions that you have. And Jake is a pro at bankruptcy law. Jake is a veteran of the U.S. Navy. He is a busy, hardworking lawyer here in Pinellas County. He is a wonderful father and husband, and he has dedicated this hour to you all to have your questions answered. So, Jake, thank you for coming on the show again today.
Oh, thanks for having me. I appreciate it.
Jake, you have a story kind of like the founding partner of our law firm. Guy Perenich was an insurance adjuster before he decided to come to the other side and just represent people that get hurt in auto accidents. You have a similar background from working in one field and then shifting over and helping the people that you help. Can you tell our listeners a little bit about your background as the owner of the recovery business?
Sure. Most attorneys, they go to high school, then they'll go to college and then law school. So I went the roundabout way. I was in the Navy for 4 years, and then when I got out, my brother and I had a collateral recovery business, which is basically it's a repossession company. So
Right.
we had that. We started with one truck, and we grew the business, and it got me through undergrad and partway into law school. And I also, while I was doing the repossession business, I was going part-time to undergrad. And I learned a lot about people in desperate situations. I also learned a lot about bankruptcy law from sort of the street level view, which has really been helpful for me to understand the viewpoint of people when they come into the office and the perception that they have about bankruptcy and sort of the common terms and how they use them. And that's how, that's how I got into this. And so, but I repossess cars and trucks and anything else you can imagine. I think probably the first thing I ever repossessed was a hot tub.
Oh my goodness.
It was a disaster, but it's a story for another day.
I could say we could probably spend a whole hour talking about some of those stories.
Yeah, that's what I got. It was fun too, because I got to work with my brother and my dad. And, at some point we just felt like the Three Stooges in this person's backyard trying to repossess this hot tub. And they were so confident that we weren't going to get it out. They just stood there and watched us.
My goodness.
And so eventually we did, but I'm sure we did more damage than anything to that. But and so at some point I decided, you see people in desperate situations, and I have a heart, obviously. So, I wanted to help people that were going through debt struggles. So I went to law school. After law school, I started working with Marshall Reisman on Central Avenue in St. Pete, and we did consumer law, and also started doing small business reorganizations in Chapter 11. And so, here I am 16, 17 years later. So
yeah, you're a local guy too. You went to USF.
Correct. Yeah.
As I did. I don't think I graduated. What was that? Cum laude, and then you went to Stetson. I went to Stetson. You graduated magna cum laude at Stetson, if I understand correctly.
I think so. I think that's what it says on there.
Yeah, and then you're also you were the president of the Tampa Bay Bankruptcy Bar Association.
Yeah.
So listeners, if you have questions regarding bankruptcy, Jake is your man. We are here until 6 o'clock here to answer questions you have. If you have questions, call us at 727-441-3000, and we will be happy to answer your questions live on the air. We are also live streaming our show on the firm's Facebook page at Perenich, Caulfield, Avril Noyes Injury Lawyers. So you can, if you don't want to have your voice heard on the radio, but you have a question, just send us a question in the comments on our live stream, and we'll be able to answer those questions here live on the radio for you. Again, the law line is 727-441-3000. Now, Jake, I'm sure there's a lot of reasons why people have to file bankruptcy, but what are the most common reasons for an individual or even a business why they have to file bankruptcy?
Well, in my experience, there is a little bit of issue with I think our healthcare system is a big part of bankruptcy, and bankruptcy is a big part of our healthcare system. I have a lot of clients that when they get sick and they don't have insurance, and then they run up the medical bills, and then they use the credit cards because they're trying to keep up with groceries and
daily
living. And so you'd be surprised at how many people have had to file bankruptcy because of some sort of debilitating injury or a health issue. So that's quite a few, actually. There is always, the credit card, sort of circle that people get into. Credit cards, they can be like a drug, and before you know it, you owe more than you can ever pay back. So people deserve a second chance. They deserve a fresh start. So people make mistakes, and nobody's perfect. So that's what we try to do, is we try to give people a second chance. But, that's not something that is abused. You can only, certain bankruptcy cases, you can only file like a Chapter 7, which is a straight bankruptcy, every 8 years. So, it's supposed to be there so that you are not a slave to your debt.
Yeah.
And so, but a lot of also what we see is foreclosure defense. So sometimes, we end up dealing with a foreclosure situation, and then we'll put it into a bankruptcy, so give the homeowner, the debtor, a chance to catch up on the house payments and pay the arrears. So but those are the mostly typical situations.
Yeah, I think the misconception with the general public is that people file bankruptcy after they lived this lavish lifestyle and spent crazy on their credit cards, and now they're trying to escape that responsibility, and in your practice that's just total opposite.
Well, I mean, there is that, right? So, but it's not as much as people think. It is not nearly as much as people think.
Right.
It really isn't. A lot of businesses are having a hard time. And so a lot of the bankruptcies that we do are people that had personal guarantees on debts for a business that they were trying to get going, or they were trying to float through COVID, and it just caught up to them. The ideal loan they couldn't pay back. But I mean, listen, there's always going to be, the few that, have that issue. And again, they, their mistake. So, but it's I don't judge, right?
Right.
I'm just there to help. So
Right. I mean, we
you
have a
take them
legal
as you find them.
We have a legal system
That's
is supposed to help everybody.
That's right. Mhm.
And not just pick and choose who
That's
needs
right.
to help. The medical bills, I have just today I had a client drop off a bill to me, and the emergency room was $32,000 after a car accident.
Mhm.
And he was like, how can it be that much? And unfortunately, that's what it is. And too many times in my practice, in auto accident cases, you have these huge medical bills, and sometimes there's not enough insurance coverage to pay off those bills. And so that person is left with those huge bills
Right.
for no fault of their own.
Right.
And so sometimes bankruptcy is the only option for
That's
them.
right. Yeah.
Yeah, but what advice do you give someone who is considering filing bankruptcy? Are there alternatives to file bankruptcy that you talk about, or?
Yeah, I mean, I think that, and I beat myself out of attorney's fees all the time, but telling people this, but I truly believe it. I don't think people should just run into bankruptcy because, they feel like they can't pay their bills or because they don't want to, right? I feel like it should be, a last resort, and that's you can see that behind the premise of the legislation where they limit it to every 8 years. You don't want to be a serial filer. So I do initially, always try to see if there's another way out, right? If you can settle the debt, or if you can set up a payment plan with the creditor, or there's another situation. I'm not a fan of there's a business model out there that it touts itself as sort of an alternative to bankruptcy. And essentially what people are doing is paying money to this
third party vendor, right? I've listened to those commercials on the radio. So.
Yeah. And so what they'll do is they'll take the money that the people are paying. So on a monthly basis, that they'll say, hey, instead of paying your credit cards, pay us this. And then that third party vendor or whatever, they will put it into an account, and then they will negotiate with the creditor or whatever. Now, some of them have a legal defense tied to that, because a lot of times that ends up in a lawsuit. You don't pay your bills, you'll end up getting sued. So sometimes they will moderately do some moderate defense over it. But by and large, I don't want to say that it's a bad system, or I don't want to say anything bad about it, but I can tell you in my experience, it hasn't proven to be a successful alternative to bankruptcy. I have had more people have more problems with it than success. So, but so I don't really endorse that at all. So, but I do endorse trying to work out a plan, or trying to figure out a way that if there's a way to avoid bankruptcy. Now, that being said, there's a lot of people out there that there really is no alternative.
Right.
Yeah.
You try the best that you can. You've tried to deal with the creditors that you can, and then lawsuits happen or foreclosures start.
Wages are garnished, bank accounts are garnished. People are going to, I had somebody come in the other day that went to Publix to get some groceries, and the bank account was frozen from a judgment creditor.
Oh, wow.
Yeah, I mean, so sometimes you really can't do anything. To unfreeze that account in the quickest possible way, I had to file bankruptcy for the person, but I also have to look to make sure that me filing this bankruptcy for this person isn't going to create a problem elsewhere. So, but a lot of times people will not come in until there has been something like that has happened.
Right. And it's usually that a bank account being frozen or a lawsuit being filed against them.
That's right.
So what happens if a lawsuit is filed against them? I know there are situations in my practice where, although we only really sue the insurance company or bring the claim against the insurance company, the law requires us to name the at-fault driver in our crashes. What happens if the at-fault driver files bankruptcy? Can we proceed with the claim against that person?
No. For the most part, right? Everything
Right.
we do is it depends.
That's right.
There's the general. For the most part, no. When someone files bankruptcy, something called the automatic stay goes into effect, which basically gives the debtor a breathing spell for a number of reasons. Because when you're at that point, it's a feeding frenzy. If you're getting sued by one, you're getting sued by more.
Correct.
Most likely. So, but in that situation. Unless the at-fault driver did something reckless or malicious, they'll probably. Listen, if negligence wasn't dischargeable in bankruptcy, I would be out of a job, right? So, but beyond that, if there was some drugs or alcohol involved, or there's some mitigating factors, there could be a way to, get that, whatever it is, not discharged, or make that a non-dischargeable debt. I haven't seen that happen, but
it rarely happens. What I see happen a lot is that the at-fault driver will file bankruptcy, and then we, as the plaintiff's lawyer, will have to petition the bankruptcy court to allow us to proceed with the case up to the limits of their bodily injury liability insurance. Because really, it's the insurance company who's paying the judgment in our situation, anyhow. And so, as long as we're not bringing a personal exposure to the debtor, we're allowed to proceed with our claim.
Right.
But you still have to go through that whole stay and everything.
Yeah, and so people call. I've got a lot of friends like you that call me, and I'll file the motion for them and make it so that they can liquidate the claim. That's all they need to really do.
Yeah.
So bankruptcy is its own court, and it has its own set of rules. So, and
it's federal court.
It is federal
court. So we're dealing with the federal government, so they have their own rules over what the state rules have too.
Yes, and there is a supremacy clause, and so there are aspects of general debtor creditor law in Florida that's trumped by the bankruptcy code. So and it can be a pitfall. So if anybody's ever said that they filed bankruptcy on their own, or if they try to file bankruptcy on their own, it can be a disaster, because it's not like flipping a light switch on and off, right?
I was going to ask you that, because I think you can, just like in a personal injury case, you can file your lawsuit on your own, but it's not wise to do. How about bankruptcy? I mean, you technically, I guess you can file your own bankruptcy, but what pitfalls did you see? I'm sure you have to jump in several times when someone comes to you and say, I tried this on my own. Now please clean up my mess.
Yes. I think that the biggest one is that people don't realize what the concept of property of the bankruptcy estate is, right?
Okay.
So if you can picture in your mind's eye a giant bucket just appearing out of nowhere the day you file bankruptcy. Now picture everything you own going into that bucket, right? So initially, that's your homestead, that's your clothes, that's
your vehicle.
It's your stocks, bonds, retirement plans, everything. Now, you can take stuff out before it's liquidated, because the idea of that bucket is for a trustee to sort of root around in there to see if they can liquidate anything and pay to creditors. And oh, by the way, they can also claw back stuff from the outside and put it into the bucket. So if you prefer to pay your mom or dad over the last year instead of Bank of America, a trustee can go after that and sue your mom or dad and get the money as a preferential transfer. Okay. If you were afraid that you were going to lose your Harley Davidson, I get this a lot, and you title it to your brother, the trustee can go after it. Yeah. So, but there are things in there that the trustee doesn't go after that you can take out. And for the most part, it's your homestead, right? And then, and now recently they finally changed the law and made it so that you can have $5,000 equity in a vehicle. For my entire career, it was $1,000 for a car. Can you imagine?
Oh, wow.
So, there was a lot. So that becomes an issue with people trying to do that themselves. Right. They end up losing a car. They end up losing something important to them that they shouldn't have. Right. So then, obviously retirement plans are exempt. They come out of the bucket. Social Security income comes out of the bucket. So, you can, having like a common knowledge of bankruptcy can be dangerous. It's, going on, like if you get a headache and you go on WebMD, that's right. You're like, oh, I got a tumor. Yeah. So you got to be careful.
Yeah. Google Esquire doesn't help you with bankruptcy.
And what's even getting, what's made it worse, Matt, is that now that there's AI, I have had people really make some profound mistakes trying to be their own lawyer by talking to Chat GPT. And and I think that's I use it myself sometimes, right? But you got to be careful. You still have to know what you're doing.
It's a building block. It's not the building.
No, it's like using an electric battery operated screwdriver to put up drywall instead of a hand screwdriver. Right, you know what I mean? Yeah. It's a power tool, but you still got to know how to put the drywall up. You got to know what you're doing. So that's been an issue lately. It really has.
I can imagine.
Yeah.
And so then they come to you after the bankruptcy court or the trustee or creditor says, hey, you did something wrong. And they come and say, hey, Jay, come please fix this. I'm having the bankruptcy court yelling at me to fix this or fix that.
Well, it's not even that they'll say that you did something wrong. They'll be like, thanks for the car. Well, what do you mean thanks for the car? Well, you didn't exempt it, or you didn't report it, or you didn't put it in the so somehow you waive the exemption, or somehow you do something that makes it so that a trustee has a shot at it, that they can get into that bucket and take that car out for themselves.
And what happens if they don't put a certain asset into that bucket, so to speak?
Well, so and this is another thing that people don't understand. When you file bankruptcy, there's a number of forms, but the basic one is the petition itself saying, I'm filing bankruptcy. Then the rest of it is mostly schedules, and the schedules are really just lists of stuff, right? Okay. So the question is what happens if I forget to put something on that list? Well, it depends. Like anything else, it depends on should you have known to put it on the list? Did you leave it off on purpose, and how much is it worth, or something to that effect? If you accidentally missed a creditor, I mean, that's understandable. But if you got a Lincoln Mark 8 in the driveway and that somehow didn't make it on the property list, right, Schedule B, then you're going to have a problem,
right?
And then people ask ChatGPT, well, if it's in my wife's name and my name, do I have to list it as my property? And so they'll go on, and ChatGPT will say, technically this or technically that. Seek the advice of an attorney, because it has it at the bottom. But it'll make them think that there's a loophole that they can use so that they don't have to put that on there. And so I've had to fix a few problems that way. Yeah.
Right. Well, that's why hiring an attorney is so important, and especially in bankruptcy.
Right. So because I remember people asking me, well, and they still do, are you afraid Chat GPT and artificial intelligence is going to put you out of a job? And I'm like, first of all, I'm not that lucky, right? So, second of all, no, it's not going to happen, because it's artificial intelligence and it can't reason.
Right. So I hear that same question all the time. But they're gonna, you're not gonna be able to argue lawsuits, or someone else is going to take your depositions for you. No, that's not going to happen.
Right.
We do go to law school for a reason to think analytically, and I just don't think Chat GPT or otherwise do that.
It doesn't think, it doesn't reason, and it doesn't. It does. Obviously, it analyzes, but in a logical, very logarithm type manner. So our jobs are safe. We're good. I think so. Yeah.
And we kind of talked about this. We talked about what debts could be discharged, and I guess more importantly, what assets could be protected or exempt from
Right. What can we
bankruptcy.
take out of the bucket?
Yeah.
Okay.
Why don't you tell our listeners a little bit about that?
So, for the most part, again, there's from a general standpoint, in Florida, you could take your homestead out. Now, there is some limitations, around that, very specific and very granular that I don't need to get into, but there's limitations, right? So, like anything,
Right.
But for the most part, your homestead comes out, and now you get to take out $5,000 worth of a vehicle, of equity of a vehicle, which it doesn't sound like much, but for the last 20 years it's been, or 30, 40, 50 years it's been 1,000, and now it's 5,000. It's been it's good. It's a good change, and I applaud the government for finally doing that. And so there's that, you have that, and then you can take out, if you take your homestead, right, then you only get $1,000 worth of personal property and stuff for the rest of it, right?
Okay.
So people typically don't have much anyways when they come. They don't have much in the bank account, but that's considered in that. The other thing that people can take out of the bucket is if they have what's called tenants by the entireties. If they own things with their spouse and their spouse does not have the same unsecured creditors, then you can claim the couch as as tenants by the entirety, or you can take out the refrigerator or whatever, tenants by the entirety. What stuff you bought under those elements is, as a married couple, with both have equal rights to it, and you bought it while you were married, that can come out. If it's a joint filing, then you're both limited to $1,000 each. So you don't get a whole lot of property exemptions. But if you don't take the homestead until you rent an apartment or rent a house, then you get another $5,000 worth of personal property and stuff that you can take out of the bucket.
Okay.
And so when I talk about personal property and stuff, I'm talking about anything that's not like real property. I'm talking about like a guitar or
the Harley,
whatever, right? So from a value standpoint, that's where everything's measured, and it's typically Craigslist value. What could you replace it for, or what could you get for it on Craigslist if you were to get something similar? And but the big exemption is obviously retirement accounts. The 401k,
the 401ks,
right? If if it's one of those things where you didn't take $10,000 out of a non-exempt savings account and put it in your 401k, the 401k is exempt, right? But there's exemptions, and then there's exceptions, and so that's you can't take an asset before you file bankruptcy and say, okay, well, I'm gonna make it so I can take it back out of that bucket because I heard this guy on the radio talk about what's exempt. So I'm gonna take all my money and I'm gonna put it into my my IRA or my 401k, whatever's protected up to the limits or thereabouts, and then I'm going to file, and it's not going to be a problem. Well, it is, because that's like a preference. Or I'm sorry, that's like it's a fraudulent transfer. Right. You're trying to put that somewhere where it's out of the reach of creditors. Right. So again, these are things that you get in trouble with. Now, if you've got a 401k or an IRA and you've contributed, regularly, and that's not a problem. You get to keep it.
Right.
So.
Well, that's good. Well, but you are listening to Jake Blanchard. He is a bankruptcy attorney here in Pinellas County. I am Matthew Noyes. I'm one of the partners at Perenich, Caulfield, Avril Noyes. We are the proud sponsors of FLA Law on the Radio, for which you're listening to. We're going to take a short break in just a minute. But if you have questions, call the law line now at 727-441-3000. When we come back from the break, Jake's going to talk about the differences between the different types of bankruptcy. So call us if you have any questions. We'll be right back.
This is the Tan Talk Radio Network.
In 1955, the law firm now known as Perenich, Caulfield, Avril Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Perenich, Caulfield, Avril, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the Tan Talk Radio Network.
We are back. This is attorney Matthew Noyes, and I'm one of the partners at Perenich, Caulfield, Avril, and Noyes, the longest established personal injury law firm in Tampa Bay. We've been helping people who get injured because of the fault of others since 1955. So we're almost approaching 70 years of helping the community of Tampa Bay. Another way we try to help is by putting on this hopefully informative radio show. It is a live call-in talk show. So if you have questions regarding the law, call us now at 441-3000. And today I have even more of a wealth of knowledge because I have my friend Jake Blanchard here, able to answer any questions you have regarding his area of law, which is bankruptcy. This past half hour, Jake has really educated me a whole bunch, and I'm sure he's educated you all as well about bankruptcy. So if one of his comments or thoughts sparked a question, this is the time to ask Jake now. But Jake, before we went to the break, we were talking about bankruptcy, and that I think there's 3 different types of bankruptcy. Can you tell our listeners a little bit about how many types of bankruptcies and the difference between them?
I'll tell there's more than 3. I mean, there's municipality.
We personal injury attorneys can only limit ourselves to 3.
Let's just stick with 3. That's good enough. That's all that really. So otherwise it's but it's you have the Chapter 7, which is a straight bankruptcy. It's a liquidation type bankruptcy, and then Chapter 13, which is a payment plan. So and that's usually for folks that make more than the median income for the same household size, and it's based on a census from the IRS.
Okay.
So, and which so
if you make too much, you can't file for Chapter 7.
So exactly,
Okay.
it's if you as a household, if the household income is more than that of the median income for the same household size in your area or in your state, but then you there's always exceptions, right?
Sure.
So you go to step 2 in the means test. The means test is what tells you if you can file or not. So it's like really a lack of means test.
Okay.
So if you've got the lack of means, then you got the 7. If you can afford to pay some folks back, or if you make enough money to pay on a payment plan, but you're not paying all your creditors back, then you do a Chapter 13. It's a 3 to 5 year plan, typically 5 years, especially if you're over the median income. And then there's Chapter 11. Chapter 11 is for small businesses. For me, for small businesses. Chapter 11 is for any kind of business, really. Huge businesses could be, Blockbuster filed Chapter 11, or, and I think Chuck E. Cheese, at one point filed Chapter 11,
Okay.
but that place is still going.
Yeah.
I don't know how.
Bed Bath & Beyond. I love Chuck E. Cheese pizza. That's really good pizza.
Well, I'm just glad they serve beer there at this point.
That's true.
So
my 2 granddaughters love it too, so that helps us to play some of the games.
So 11 is typically for a business. It could be for a small business, and there's another type of 11 called the subchapter 5 11. So if the business is a small business and it has less than a certain amount of debt, it can do somewhat of a I don't want to say abbreviated. You still have to, maintain the rules, but they do augment them a little bit. But it's a more of fast flowing. It's more of a fast track of a bankruptcy because it's you're not dealing with hundreds of shareholders and things like that. So you've got a little bit more. It's not nearly as complex. So, and I do a lot of small business sub 5 Chapter 11s where the business that's less than 5 million or 4 million or something like that, and they've got less than 80 employees or so. It just depends. But and those give me a lot of satisfaction because it's really nice to be able to help turn around a business that is struggling.
I can see that. I see if people are working hard to build the business and they hit a rocky point, and the choice is either to give up and walk away or to restructure and try again. So
yeah, and I think that anybody that has been in business for themselves hits a rocky point. It's just it's inevitable because life is life. So, and that's a good way to help them. But
and the business cycle in Florida changes, ebbs and flows like you wouldn't believe. If you're trying to run a restaurant, anytime it could be booming 1 month, dead the next month. Yeah,
I mean, I have seen the restaurant business ruin many a financial career. Unfortunately, it's I mean, especially lately, I do have a number of clients, but from a reorganization standpoint, a restaurant's incredibly difficult to a reorganization because a reorganization, the business has to be viable. It has to have cash flow. It's got to be able to maintain it. It's some operating cost, but there's a number of businesses out there that only the vendors are making money, and there's only a few handful of people that are making the money, and then the folks like the two of us that are the small business person trying to get it going is we're just they end up just working just to pay creditors, and so it's you get all types, but a lot of and I do a lot of that, but I spend most of my time on that, but I do most of my cases are the Chapter 7 consumer, Chapter 13 consumer type that.
Now, Chapter 7 and Chapter 13, if I understand that, we're talking about the bucket before we took the break. The Chapter 7 is they look into that bucket after they take out all the exempt, and they pay what they can pay from what's left in the bucket.
Correct.
And then it's a fine line. The creditors have to walk away, in essence, and the debtor is released of the debt.
Correct.
But Chapter 13, they look at the bucket, but they also look into the future. Is that
That's right? Yeah.
And then the debtor may have to pay into the future.
Correct.
For those creditors. Okay.
Well, yeah. So that's exactly right.
All right.
So it's a repayment plan.
CJ.
I appreciate that. That's good.
Yeah. So why is there any difference or beneficial for Chapter 13 as opposed to Chapter 7?
I mean, that's a really good question, because sometimes, if you're in that Chapter 7 scenario and you do have that something or other that is in that bucket, but you don't have an exemption by law that you can take it out. Chapter 13 gives you the opportunity to pay the value of that.
Okay.
So you can keep it. So if you really want the Harley that bad, you've got to pay for it. You got to essentially pay the value, at least the minimum of what they would get in a Chapter 7 over the 5 years.
Okay.
But Chapter 13 is it's a commitment, right? It's 5 years. Most people they don't want to have to deal with that, but you can only do so much within the confines of the bankruptcy code. So I've had people come in and just say, well, I 7 or nothing, and I'll tell them, okay, well, this is what's going to happen, and okay.
And they file for Chapter 7. Can they then start up again and then file file for Chapter 7 again next year, the year after,
No.
if they get in trouble? What?
No, it's every 8 for Chapter 7. From file date to file date. It's 8 years.
Okay.
So if they wanted to do a 13 and still get the discharge and a 13, they'd have to wait 4 years after a 7. So there's there is timing aspects of it. Now there's something called the Chapter 20, which is someone.
So there were more than 3.
So there is. Well, it's because it's a Chapter 7 and a 13.
Okay.
Yeah. So it's a Chapter 7 where
I didn't know there was going to be math involved.
Yeah.
Okay.
There's more math than I care to admit. In this. So, but it's if it happens when say discharge unsecured debt, credit card debt, what have you. And then soon after that, you fall behind on the house. Then you can file 13 to, cure the arrears on the house. Even though you did a 7, you're not going to get a discharge, right? But you don't really need one because you got one in 7.
Okay.
So that's a Chapter 20. So yeah, that happens quite a bit actually because people, unfortunately, life happens. They overestimate the amount of income that they're going to have in the future, and they miss a house payment. But they recently
Somebody loses a job.
Somebody loses a job, but they recently got discharged in a Chapter 7. They're facing foreclosure. So Chapter 13 bankruptcy gives them the opportunity to cure the arrears of their mortgage over 5 years. I mean, there's a catch to it, like anything else. It's not as easy as it sounds. You can also apply for a mortgage modification in there, but there's nothing in there that makes the bank give you a mortgage modification. The bankruptcy court will make them consider it.
Oh, I see.
They'll make you do a mediation, right? So, but there isn't anything that's going to make the bank give you a better deal. So, but you got to try. So, and believe it or not, it happens quite a bit that we do a mortgage modification in a Chapter 13, and it happens. Like I'm surprised at how often people get modifications or are able to keep their house in that Chapter 13 process by applying for a modification through the bankruptcy court. So,
well, I think it's good because it gives the person, the debtor, the opportunity. If it's not a restart, if it's not a new start, because it's Chapter 7, at least it's a restart.
Exactly.
Where they can, dust themselves off. Yeah. Get back to work. And work to pay back the
That's
arrearages.
Right. So
that's a wonderful process.
Yes. So I say that there's a fresh start, like the Chapter 7. There's the restart, like we just talked about with the 13. But what bankruptcy doesn't do, and what it is very specifically programmed over the last 100 or so years not to do, is give someone a head start. Bankruptcy does not give you a head start.
Oh, okay.
So if you try to get a head start from using bankruptcy, then that's when you're going to have a problem. And people think that they're clever, or they have an attorney that is willing to, bend the rules or do whatever one way or another, but it catches up to them, right? Yeah. So, you just do it, just play by the rules, and you'll be fine. It's there to help.
They have these set up to help you.
Right.
So that's a wonderful thing. Now, filing bankruptcy can have an impact on a person's credit score.
Oh, yeah.
And on his chances of employment, right?
Okay. So, I mean, I was dealing with that today. I mean, so bankruptcy, yeah, it's going to, if you're a car accident attorney, right?
Right.
I don't, personal injury attorney, but deal with car accidents quite a bit. If you think about collision to a vehicle, right? Like if you miss a payment on your credit card, it's a ding. If you miss 3 or 4, then you crushed an offender. If you file bankruptcy, you wiped it out. Yeah. It's totaled. So you rebuild it though, right? You get a chance to rebuild it, and you have a place now because the creditors understand that you can't file for another 8 years. They'll give you another chance. Credit card companies are surprisingly liberal with their lending standards, if you can imagine. I've had people get credit card offers in the mail, a month after they file bankruptcy without a discharge.
I've heard that.
It's bizarre, but it happens because, it can be a drug, right?
Right. Explain it to our listeners. Somebody files bankruptcy,
Mm-hmm.
they get a discharge,
Right.
then all of a sudden they get all ththese credit card applications in the mail.
Right.
Why would those creditors be wanting these people who just filed bankruptcy get a credit card?
Because they just filed bankruptcy, they got a discharge. They're the most attractive, vulnerable targets out there now because they can't file for another 8 years.
Okay.
So they got another 8 years to
collect the interest.
Collect the interest and to rope them back in.
Yeah.
And listen, I'm not saying credit cards are bad. I've got credit cards, right? But if you use them for emergencies or you use them in moderation, like anything else in moderation,
right.
They're a fine tool. So I'm not saying that they're bad, but when you get into this cycle and you're just paying the minimums, you're never going to pay that off.
You're just spiraling downward.
Right. You're not really going to be, because at some point that interest is going to increase and then it increases and then it increases and then it increases. You do pay the principal, but it is so the amount of money that, if you were paying minimum payments, like maybe 10 cents or something literally goes to like the principal, if anything. So it's just, it could get real out of hand real fast.
Now, I think something changed. I don't know if it was recently, but now on the credit card statements, it says if you only pay the minimum payment, it's going to take you X amount of months to pay off this balance. I don't think it used to say that. I think something changed where they required that now.
No, so and there's there's some consumer protection laws in place to help people. And believe it or not, that particular law that you are talking about was promulgated mostly by credit card companies because they were tired of getting sued. They were tired of getting for predatory lending or whatever. Or not only that, but trying to make it so that they have better clients. So I mean, it was actually a collaboration between consumer protection and credit card companies saying, it's like on a cigarette. If you smoke this, you're going to get cancer eventually, kind of thing.
Right.
So I don't think it's to that degree, but I felt like that is somewhat of a recent development. I mean, in the last like 20 years or whatever, when I say recent development, but people don't read it.
No,
they don't care.
No, that's true. That's true. But there is a way. It sounds like there is a way that once you file bankruptcy and you get a discharge, the bankruptcy is on your credit report.
Yes.
But there is a way to rebuild your credit even after that.
Correct. Yeah.
And that's if you do it wisely,
right.
You do it in moderation and slowly build up.
Yeah. I mean, it really is a process. And so bankruptcy will initially it'll wipe your credit report, wipe it out or wipe out the score. So, I mean, it's just by nature, right? As it happens, because you're at risk. But then as you reestablish yourself or you reestablish your creditworthiness, it rebuilds. And it rebuilds surprisingly fast. I mean, the bankruptcy itself will stay on the credit report for 7 years after the discharge. But I mean, I have clients that, file bankruptcy, 6 or 7 months ago, got the discharge and they're in the 700s already.
Wow.
So, and, to get now FHA regulations allow someone to apply and possibly, I shouldn't say apply. I mean, you can apply anything, right? But you're able to get a loan that's FHA backed after discharge after 3 years, which is I think the if it's a veterans or VA one, it might be a little less, or it might be around 2 years. I don't know exact date or exact times, but so because that gives you time, right, to establish your creditworthiness to get back into I guess you want to call it the circle, because it is, that's
get
what
back into standing.
That's right.
Prove yourself that you got this refresh,
right?
You know,
that you got a fresh start, and that you're using it wisely.
Right.
So, but
well, now there are some situations that there's debt that there's a cosign or a guarantee to the loan.
Mm-hmm.
What impact does one person filing bankruptcy have on the person who co-signed the loan? Let's say
the person that co-signed the loan is still on the hook for it.
Okay.
The person that,
So I just bought a car. I just bought a truck for my son, 18-year-old son, this weekend, and I co-signed the loan.
Right.
So he's building his credit.
Right.
But if those bills aren't paid and he files bankruptcy,
that's your
get the keys
that's
from my
him.
Apple.
I hope you like that truck.
I get the Ford.
Yeah.
That's right. It doesn't. You don't get to extinguish that loan.
Not for the cosigner now.
Right. So he's still on the hook. And what about if you're a business owner? How can a business owner protect themselves from personal bankruptcy, even if their business has to go into bankruptcy?
Look. The bankruptcy is here. It's here for a reason. The country has it for a reason. It's actually rooted in the Constitution. So, this is a free market system. So it encourages risk. But if it's going to do that, you can't. It's got to give you. It's got to give you a way out. It's got to give you an ability to, if things don't work out, to get that fresh start. So, and that's what bankruptcy is for. The country was built on the backs of small business people, no doubt.
Right.
So, bankruptcy is incredibly important in that area because nobody is going to give you a loan for anything you want to do with a business just on that business. They're going to require a personal guarantee.
Okay.
So people will get an SBA loan and they think, well, the SBA will pay for it if it doesn't work out. Well, then the SBA is going to come after you for it.
Okay.
So and so they get these astronomical loans with what they call personal guarantees, which is essentially the individual guaranteeing the payment for the business on the loan. And it's on. Very rarely do I see a credit card that is just for a business that doesn't have an individual as a backstop.
Okay.
So the individual is always going to be the backstop, but that's what happens. You end up getting just hundreds of thousands of dollars of business loans, and it can be a house of cards. And then you can't pay one back, you can't pay the other back. One starts suing you, the other one, starts suing you. There's this just insidious business model out there called MCA. I almost use the term lenders because that's really what they are. But MCAs are merchant cash advances for small businesses.
Okay.
So what the actual how they get around usury is they'll buy a certain amount of receivables from the business for a certain amount. So say they buy $150,000 in receivables for $70,000 or whatever. And so they'll give you the $70,000, but then they'll take money directly out of your bank account, or they'll take money directly out of the point of sale system. So they start diverting money away from things like paying rent or getting vendors paid or whatever. So it ends up being the kiss of death for a business, really.
Sure.
If you get more than one, right? One or two, and you pay them back, that's fine. But essentially, you're paying $150,000 on $70,000. Now they say that's not a loan because they hide it as you're buying receivables. Now there's case law that in bankruptcy, this is a hot topic. So there's recent case law that came out, and there is, cases that say, no, it's a loan. And there's other cases that say, no, it's not. Wow. So it's like, what did they used to say? If it quacks like a duck, walks like a duck, it's a duck.
Yeah, that's true.
So that's kind of that's my view of them. Yeah. But, but those have personal guarantees.
Right.
And so, and that's really what ends up bringing down a business is those daily draws or weekly draws on paying these merchant cash advances.
So if a individual or business owner needs to ask you questions, we're about to wrap up the show. How can they reach you, Jake?
They can reach me at my office at 727-531-7068. That's 727-531-7068. My website is jakeblanchardlaw.com.
Easy
and I'm
enough.
over. Yep, and I'm over on 49th Street in Pinellas Park.
Perfect, Jake. I really appreciate you showing up and answering all those questions and really informing our listeners.
No, my pleasure.
Thank you for listening. This is Matthew Noyes. I wish you the best and drive safely and watch out for those who don't. Good night.
WTAN Clearwater
FM 106.1.
WDCF Dade City.